Ladies and gentlemen, welcome to ICRM's May session. Thank you very much for taking off your busy time to join us. So a bit of house rule, kindly mute yourself while speakers are speaking so that we don't interrupt each other, and allow us to welcome our panelists, Guillermo Christensen, Patrick Rappo, Nigel Morris-Cotterill, and Dean Smith. And today's session is one of the most exciting and very up-to-date topic, more sanctions. For the past 3 months, we have seen the EU introducing a lot of packages within 3 months, and other than clarity to what are these packages, we'd like to invite our panelists to discuss what are the risks of violations and how can we go about doing it. Without further ado, I'm going to pass over the floor to Patrick, our chair. Patrick, the floor is yours.
Thank you. Could I just remind everybody to please put their microphones on mute? I think, Irene, we have got you not on mute. Excellent. Thank you very much indeed. Okay, so again, I still think we've got some background noise there. If we could please put ourselves on mute. Excellent. Okay, I think we're now muted and ready to go. That's the problem these days with virtual conferences and mute buttons and so on. So what we're going to do is really talk through the sort of fast developing sanctions landscape. We have today with us a very erudite panel who bring with them a lot of experience, both from the legal sector and also from the business sector and consultancy sector. So we have hopefully got all bases covered. At the end of the session, there will be time for sort of Q&As. And what we are going to do is really just have a discussion between the group as to where we are at currently with the sanctions process and the implications for changes within the EU and in the US and other parts of the world, and then really just looking at the risks of violating and what that kind of implies, and also the more generic topic of what's their effectiveness. Do they actually work? And ultimately ending up with a sort of look at what's the implications for other jurisdictions who sanctions in relation to Iran, in relation to China, in relation to different locations that have had sort of problematic issues in the past and currently. Is this the new way forward? So that's the sort of agenda which we're going to look at. Just by way of background, just to introduce myself, and then maybe if we can take turns with other speakers to introduce who you are in case people don't know already. My name is Patrick Rappo. I'm the global co-chair of our DLA Pipers Compliance and Investigations Group. My practice involves really proactive compliance work in relation to bribery and corruption, money laundering, fraud, sanctions, as well as investigating breaches and then responding to regulators. Previously, I was the head of the bribery and corruption divisions at the UK Serious Fraud Office, which predominantly dealt with bribery and corruption, but we did have some sanctions cases in the oil for food Iraq scandal from many years ago, those of you old enough to remember it. And obviously in terms of UK issues, which is what I focus on, although I'm global co-chair of our group, I am involved primarily sat in London. And obviously in the recent past, there have been an enormous amount of changes, which we'll look at shortly. So that's the overview of who I am. And if at this stage I can hand over to Guillermo, who can introduce himself and the his kind of US background in relation to this. And if I can just remind people to keep themselves on mute as we go through, as the background noise can interfere with our sound quality, which is, as we're recording this, we'd like to keep it as crisp and clear as possible for other people. So Guillermo, over to you to introduce yourself.
Thank you, Patrick, and a warm welcome to everyone. In the beginning of the week here in the US, we just had our Memorial Day holiday where we commemorate the service of all our forces around the world and those who laid down their lives. So just something to note here. So my name is Guillermo Christensen. I'm a partner at ICE Miller, which is a law firm here in the United States. And we do a substantial amount of work with international clients as well as with US companies that export or import from international locations. My involvement with OFAC sanctions dates back to when I was in the government. I spent quite a long time in the intelligence community here in the United States, primarily at CIA. And OFAC, the Office of Foreign Assets Control, which is the primary entity here in the United States that deals with international trade embargoes and sanctions, comes out of the 1940s and World War II and efforts to try to control the amount of money that was flowing back then to Nazi Germany. Since then, it's become one of the most powerful regulators of international financial transactions, and we can get into that in many different ways. My work in that area covers everything from straight up compliance advice to clients. In other words, what can we do? How can we do it? How can we mitigate our risks? What's the best way to structure a transaction to reduce the cost of compliance with sanctions as well? And then the other side of it is more when things go wrong, meaning an allegation may be raised internally by a company, sometimes by a whistleblower, sometimes by a call to the compliance hotline, in which someone notes that something is being done that appears to be a problem under a particular sanctions regime, and we will be involved doing investigations, what we normally refer to as an internal investigation, for the company's benefit. And then the more extreme version of that, which I hope none of you ever have to endure, is when the government, primarily OFAC, but sometimes if there's criminal issues through the Department of Justice, initiates an external investigation that informs the company, and then the company has to respond, and we handle both the response to the government, including any filings that have to be done, but also quite often we will do a parallel investigation that we try to accelerate so that we can, in a sense, stay ahead of the government investigation so that we can better advise the client as to the liabilities and issues that they may face if they choose to go forward in either a court setting, which is very unlikely, or in the process of doing a voluntary disclosure. So I'm very pleased to be here with you, and I think I will turn it back over to Patrick for the next person to introduce themselves.
Excellent. Thank you very much indeed, Guillermo. Ghizlane, can I hand over to you to introduce yourself and give us your background? And then you can decide who to nominate between Nigel or Dean thereafter. Okay, I think you might be on mute, Ghizlane, so you might need to unmute. it's that modern problem that we always come across. But anyway, over to you to introduce yourself.
Hi everyone, I'm Ghizlane. So I have over 15 years of experience in compliance, which includes financial security, corruption, and bribery and fraud, and data protection. So today I'm a freelancer, so I'm a contractor, and I help companies, large or medium, to implement the proper, I would say, compliance program to mitigate their risk or to investigate some breaches that can happen in, I would say, many regulation, not only EU, but it can be US regulation or even UK-based regulation. And I'm based in Paris, and I'm very happy to be here today. Nigel?
Over to you, Nigel, to introduce yourself. Or find the unmute button, whichever's easiest. But if not, Dean, do you want to? Oh no, Nigel's unmuted himself. He's back online. We can see him clearly. So over to you to introduce yourself, Nigel.
I'm the technologist in this group, and I can't make Zoom work. Which is really bizarre. I'm Morris-Cotterill. I began working in the field of financial crime risk and compliance in 1994, my second career after career. I specialize in strategies. I'm always looking over the horizon to see what is going to go wrong long before other people see that it's going to go wrong. So I'm looking at things that will perhaps not go on for another 15 years. And the idea for that is that I'm looking to minimize the friction, minimize the disruption of constant change. And it's surprising how, if you look at history, if we can talk about history in the past 25 years, that we can see that there are in fact trends. There's not very much which takes us by surprise these days. The biggest surprises are regulators and others who are imposing their will to say, this is what we want you to do now, regardless of what you think you want to do. My function is to work with organizations to say, we know what the regulators are going to have as their priorities. We've always known what they're going to have as their priorities. We can build those into the system now, so we don't have to keep changing the system, which means the staff don't get angry because we keep changing the system. Dean.
Hi, good afternoon, everybody. Dean Smith from UK originally, now in Barcelona. My background started in government in the UK, investigations and onto private investigations and crime fraud prevention with National Telco in the UK. And from there, I set up a consulting enterprise and have been pretty much in that space ever since. So largely my background is in risk management and assurance of the revenue chains for businesses. But the last sort of 12, 14 years or so have morphed more into operations. And so I'm helping businesses now both manage risk, but also grow their businesses based on a sensible risk balance. And it includes a few years with a financial services company managing finance operations. And of course, in that particular space, you are very mindful of sanctions because all of your supplier relationships need to go through due diligence to assure that you're not paying sanctioned entities and so on. So I'm coming at this from a very practical business perspective, and it's useful to get the knowledge of the team around me here to learn from them as well.
Thanks, Dean. That's super helpful. And just sort of pivoting back to me, just in terms of a kind of UK overview. Some of you may have been present on our earlier call where we were discussing the sort of developments in the immediate aftermath of the Ukraine crisis. And you may recollect that I was speaking about the Economic Crime Act in the UK at that stage, which I think is an absolute game changer and effectively aligns the UK much more closely with the position in the US. And I think for those who are from law firms or those who are working in business, sanctions, I think, is going to be the next big ticket issue in the UK and Europe, I think, for the next 3 to 5 years at least. And the significant changes which have been brought in on the UK side are essentially to make companies strictly liable, as in automatically liable, for paying any sanctioned entity. So as a result, very similar to the US position, where if you make a payment, you are automatically effectively at fault civilly and you are liable to penalties. Where the differentiating line comes in the UK is that if you have knowledge or suspicion that the entity was a sanctioned entity, that brings criminal sanctions against you. So it now makes the pool of people who are potentially liable a lot broader. And it means, in terms of financial penalties and the ability to extract those from companies, it makes the pool of assets potentially coming into UK PLC much greater, and apart from obviously filling the big black hole, which is COVID, and all the monies that have been effectively either handed out to those that needed it or frittered away, depending on your viewpoint, it means that the government will have a huge amount of monies potentially coming into its coffers in relation to sanctions enforcement, be that civil enforcement or be it criminal enforcement. But if a modicum of those revenues are given to OFAC, which is the office in the UK that will be the OFAC equivalent that is dealing with sanctions breaches, and if that goes towards their increasing of resources, increasing of personnel, increasing of their enforcement activity, those two things, the legal change making companies liable for any payment to any sanctioned entity, and also the giving of monies back into the enforcement division relating to that, will bring seismic effects, I think, in UK enforcement generally. So I think those two things are a massive change, and I think they really align the UK much more with the US. And I know, Guillermo, you've had great experience of the US development, so it might be worthwhile just for you to give the audience an overview as to what might be happening down the end of the telescope if people are looking down the line, and if there is a prospect of the UK and Europe replicating the US system. So thoughts from you first.
Absolutely. Thank you, Patrick. And I think what you've described, I think, is a fascinating development, because it is potentially, like you say, a game changer in the sense that for the last maybe 30 years, the primary risk for most international companies, most companies doing business internationally, has been the risk of violating OFAC sanctions. And the reason that is a global risk is almost all of these transactions touch the dollar-based economy, as everyone on this panel is well aware, whether directly because a US bank is involved, or I'll say not indirectly, but in the background because of the correspondent accounts, the correspondent bank accounts that are used by most international institutions to clear transactions from one country to another. And it's impossible for most companies to know when that is going to happen, unless they're very sophisticated or have a lot of experience in the financial sector. So you may often find a transaction between an entity, say in the Emirates and UAE, that is purchasing or exporting or doing some international transaction with an entity in, say, Africa. In fact, those transactions will touch the US dollar-based financial system very directly, and often lead to investigations and inquiries from OFAC when there's some nexus to the United States. I think one of the interesting things here about the way that OFAC sanctions have been developing in the last 20 years or so is they've been both much more aggressive, meaning that the programs have become far more complicated, and that we've seen a development not just focused on sanctioning individuals or companies on the so-called SDN list, specially designated nationals. Some people refer to it as the blocking list. That's the traditional concept of sanctions that most people understand. Someone gets put on that list, you can't do business with them, you can't touch their property, you can't have any dealings with their property. But OFAC sanctions have gone to a much more sophisticated and difficult to comply type of regime in the last, well, I would say certainly since the September 11th attacks in 2001, when OFAC became part of that global campaign against international terrorism. And over time, the sanctions have become what most people here refer to as targeted, meaning they apply to certain sectors in different ways. They apply to certain countries in different ways than they apply to others. And that's where the difficulty in compliance has become more extreme. So Russia is a great example of this, probably the most complicated set of sanctions that are in existence right now. Since 2014, when Russia invaded the Crimea, the sanctions there have first targeted specific sectors. Energy was one, for example, but not all energy, as we all know, because the Russians were exporting oil and gas to Europe and around the world without a problem. But the sanctions were targeted at certain types of activities, deep water exploration, for example, Arctic drilling. So areas where high technology and international know-how were critical to the Russian economy were some of the first that were targeted. Interestingly, the sanctions often are combined not just with the OFAC piece, but with the export control piece, which is something in the United States, and I think in the EU as well, has been more and more common. That is, not just you can't do business with this entity, but you also can't export those services, those goods, or that technology to other entities. Obviously, if you're in a business that touches some level of exports like that, it can get quite difficult to be sure that you're complying not just with the prohibition on exporting to certain parties, but also the things that you can't export of the technology or the services. An extreme version of this is now the case in Russia as well. OFAC recently imposed an embargo on the provision of professional services by US persons into Russia. That means accounting, consulting services. Very interesting broad prohibition on that. So a consulting firm, for example, can no longer, subject to a lot of limitations, no longer provide those services into Russia. An accounting firm can't do those things. Obviously, those are all elements that limit the ability of Russian companies to, in some ways, mitigate the risks of sanctions on themselves, because some of those services might give them advice on how to structure their businesses in a way that might reduce that risk. The other thing that I think I would just point out that I think will be very interesting to see in the UK and EU context is OFAC for, again, quite a number of years has put a great deal of stress on addressing the perceived risk of sanctions, evasion, and facilitation. And the reason this has been crucial in the US context is many US sanctions have a secondary level of effect. In other words, it not only applies to a US person, a US company, some of them, particularly Iran for a long time, also apply through extraterritorial types of applications to non-US companies, banks in particular. There was a lot of concern in the US about the degree to which US companies might get around sanctions by getting facilitators or others to do things for them that they could not themselves do. OFAC has very clear prohibitions on all of this. I think in the case of the Iran sanctions, that's probably a greater risk than in the Russia case, because obviously most of the world now is kind of lining up along the same parameters for sanctioning Russia. But it's an area where the US regulators have been greatly concerned. I'm going to stop here at that point in the discussion, and I'll just sort of reserve for the next part, I think, the question about penalties and enforcement, which I think is still an area where there's a great deal of ground to be made up between the European and UK experience and the US, and maybe give you some ideas of how that might look down the road.
Yeah, that's super helpful. Thank you. And Gillian, just moving across to you in terms of you can be our spokeswoman for the European side of things. What are you kind of seeing there, and what's your kind of look down the telescope as to what might be coming up, across Europe more generally, as the UK technically is no longer in Europe, even though we're a little blot on the edge of the landscape still. We have officially removed ourselves from it, although relatively, I think, aligned currently regarding sanctions. But what's your view as to the European angle? I think you're still on mute.
Sorry, definitely. So I think that since 2014, the strategy in sanction in Europe is much tougher. So they are looking for more rigidity and trying to be not only in sanction, but as mentioned earlier, Guillermo, the export control. We can see that for Russia, for example, since 23rd of February, as of today, we had already 6 pack of sanctions, 6 package, which is quite a lot. And yesterday night, it has been decided that actually by end of the year, will cut off 90% of our exports in oil, which is something that is quite remarkable, because we have to remember that in Europe we have 27 members and that we could not decide anything without the agreement of all of them. So there were many summits and discussion and negotiation, I believe, so on this topic. I believe that Europe is trying to push harder, instead of thinking of energy and how much it will cost to the population. It's more thinking of how to stop the war and keep peace, because Russia is literally on the door of Europe and stepping in. It's something that is, I would say, new, and that it's a good thing, if we ask me. I believe that we need to be stronger in sanction and export control. Unfortunately, we do not have many examples where it worked out well, except Zimbabwe and maybe South Africa, but I believe South Africa's political pressure was very strong, so that helped too. So as of today, if we see the fact and the impact, can we say that actually it really works? That is a good question, because sometimes it worked, and with other countries like Iran, we're still in the same way, even though when sanctions are getting harder, the only thing that we can see is that the population is getting more impacted. So with some wish is that when the impact is very strong in the population, we can hope that actually the political bodies will find a way to make it work out and try to stop the behavior that we're trying to protect. For example, human rights here for Ukraine. So I would say that it's getting tougher, and that is you have many examples. Oil is one of them, and I think that it's a good one, because actually when you look at the bill, Europe was kind of financing the war because the bill is quite strong for the oil. On the other hand, adding more banks in SWIFT, removing them from the SWIFT, I would say that's something that is very good too, that will help. If I remember well, last night they were trying to discuss Sberbank to cut it off from SWIFT. So I think that will help too. But it's sure that we have no vision. I don't see that, for example, the behavior change, because they are always trying to find alternative ways. Those economies are not, even though we disagree with them, the behavior and the way that they are dealing, unfortunately, they do always find a way. And that's the thing, is that today they are trying to find Eurobonds, there's cryptos, assets. So it's very difficult to predict if it really worked.
Thank you.
On my side.
Nigel, any further thoughts from you before heading across to Barcelona and Dean for his takeaways? No, I think you might be on mute, Nigel. Nigel, I think you're still on mute.
Have I done now?
Perfect. Crystal clear.
Okay, right. I don't know how to do that, so if it happened without my knowledge or consent. Usually it's my function to be looking over the horizon, a very high-level umbrella approach to things. And I don't normally look at the practical stuff in a session like this. That's why people take me into their offices. But I want to have a look and set some of what we're looking at in context, because we're all being driven very hard by regulators, legislators, policymakers, and for that matter, keyboard warriors, who have a motive for what they're doing, but their motive is not helpful to us. What really matters to us is to understand the fundamentals of the processes and to see to what extent we can standardize those processes so that we don't have disruption and expense, and for that matter, so we're not always reacting to the latest thing that's in the newspapers or that some politician has been screaming at us for. And I think if we look at correspondent banking, for example, we shouldn't call it correspondent banking because it's not, it's a payment service. And while we talk about it as if it's something very modern and very new, in fact, what we call correspondent banking is quite simply exactly that which was created by Chinese merchants 4,000 years ago on the Silk Road, where they wanted to move their money from the north of the country, where it was basically confiscated by rulers who confiscated anything they could, and it was sent down to Canton, which is why Canton became such a very rich area. And it was done by a system which is exactly what we now call correspondent banking. So while we look at things and think this is all very modern and shiny and new, in fact, it isn't. Similarly, when we're looking at the question of the US and its the way that it takes sovereignty over trade in its own currency, it's only trades that are made electronically between banks or by some messaging system between banks. So it only relates to money which is in the bank. It doesn't relate to cash. And the reason it relates to money between the bank is that it takes the view, the US takes the view, that when money is, where there is a settlement between two banks at the top of the correspondent bank chain, that takes place in Manhattan, and therefore that brings the transaction within the bounds of the US law. And it's not a new idea. Again, it's not exactly 4,000 years ago, but it was first generated by Robert Morgenthau, who was the district attorney for the Southern District of New York, that is Manhattan, in the 1970s. And you can read about how he worked this out in a book by Clark and Teague, published a little bit later, but referencing the work done in the 1970s. So I think that we get an awful lot of people who are running around saying that we have new stuff that we have to pay attention to. But if we learn the lessons of history, there is very little ripple effect, very little ripple effect. There are small changes that we need to make, but we can centralize what we're doing if we understand where we've been, we can see where we are, we can see where we're going, and it's really not that complicated. I think that it's also important to look at the fact that that sanctions, particularly in the hands of the USA, are, as was said a few moments earlier, it doesn't only affect big companies.
Is it just me, or have I lost?
Yeah, I think Nigel may just have been lost and auto muted. But Dean, while we're waiting for Nigel to join us again, what's your kind of thoughts on this area and sort of that looking down the telescope side of things?
Yeah, looking at it from the just the business angle, and sticking my finance operations hat on again, I think there's a lot of larger companies that are not panicking as such, but they're having to expend a lot of effort in terms of revamping their supply relationships, onboarding and ongoing checking processes. And as Nigel says, these are things that are in larger companies pretty standardized. It's really just a matter of playing with parameters and so on. However, I do see that there's quite a big improvement probably in the share prices of the sanctions services and software companies at the moment, because the ones that can keep abreast of all of the relevant rules, regulations, and people and entities that are under sanctions and can supply that electronically are going to do quite well. Most of the grunt work is done by systems in the organizations I've worked for. Smaller companies not, so they're really dependent on outsourcing that, but the larger companies have their own teams and processes to do all those checks and make sure that their relationships and payments are in order in terms of sanctions compliance. So I think there's a huge rise at the moment in reorganizing the way those things work in the last few months, which is a critical dependency on these technology and data providers to facilitate that. It does also mean, likely based on the UK approach, that the companies are having to lower their parameters in terms of what they check, because of the natural liability that you have now just by processing it. Even if you've done a reasonably good job, the fact is you're going to be penalized. So where there's a cost, there's likely an opportunity to reduce that cost of non-compliance by doing the job more thoroughly. So I suspect now there are certainly more calls on the sanctions checking services, but also probably more people involved in finance operations and procurement and supplier management to make sure that the entities they're working with are compliant. So there is a cost to business in this, both in terms of software and licensing, but also the people side, and of course the re-engineering of those processes. And once these things change, they usually stay about. So any changes they're making right now to those processes will stay in place, but they may just adjust those parameters on the checks in future when sanctions start to get lifted, if and when the war ends and Russia removes its troops. One thing I did note recently, I did a fraud awareness, executive fraud awareness workshop a couple of weeks ago to a fairly major enterprise. And one of the case studies we put there was a really interesting case for Google and Facebook in 2013 to 15. They had $120 million stolen from them because of an organized group of fraudsters pretending to be one of their suppliers. So, and they did a very good job in synthesizing, spoofing that particular supplier. It did suggest some internal involvement as well from either the supplier or Google or Facebook, but most likely the supplier. The leader of that network got put in prison in 2019, but $120 million it took for that to be recognized. And it sort of suggests that if you really want to plan to get around sanctions and do things thoroughly in the way that this guy did for financial gain, then there's always going to be a way to do it, and in a fairly complex and structured way. And if you're organized enough, it's going to be very difficult to track these people down and to detect them through the standard mechanisms. So I'm going to be interested to see how the sort of fraud world morphs to enable sanctions evasion over the coming months. It's already happening, I think, in major businesses. But I do also suspect there's going to be more state sponsorship of these types of activity. We've seen lots of cybersecurity sponsored operations from Russia in particular over the last 10 years. So I see no reason why they couldn't morph that into more direct fraud and spoofing or setting up false entities to keep the cash coming in as well. So that's my view from the sort of commercial side. It'd just be interesting to watch the next few months as to how that materializes in the real world.
Thanks, Dean. And Nigel, I think we've got you back online now, and you were sort of discussing correspondent banks and the like and the issues there. Is there anything else that you were looking to conclude with on the points that you were mentioning before?
Well, I was looking to say that it's very interesting to look at the big companies, but it's the little people who find themselves subject to sanctions quite often, and they generate an awful lot of lessons for the big companies. And one of those is, for example, the guy who worked in an American company all his life in the USA, and then retired to Iran. And when the American company paid his pension into an American bank, and then he drew on that American bank from Tehran, the American bank was sanctioned. Clearly within the rules, but it seems that the sanctions were perhaps a little harsh in the circumstances. I think it's also things like the Boeing 747 that was trapped in Iran. It couldn't get couldn't get components for it. It needed the air compressor to go under the pilot's seat, and so an arrangement was made for that to be bought, believe it or not, on eBay, sent to a drop site in Miami, where it was shipped to Hong Kong and then to Iran, and that also ended up with sanctions. Again,
Oh, I think we may have lost Nigel again. It looks as if he's gone offline. So we've kind of looked at the differences across the EU, the US, the UK, and sort of looking down the telescope. Really, the next thing we want to look at is the kind of penalty piece, which is the bit that Guillermo didn't answer the last time and left and put a pin in for the future. So we're just about to return to that pin, but just before we do so, certainly on the UK side, this is largely uncharted territory because we don't have a huge history of sanctions laws, sanctions enforcement, and sanctions breaches and penalties as a result. Certainly the current guidance is that on the strict liability front, which is the new sort of legislation that fines can be in the region of 50% of the actual payment made. So that's a very significant and chunky penalty, effectively the return of the monies and that 50% on top. So it does have quite a financial sting in the tail, but what we haven't seen is really that translating into business and translating into enforcement. So Guillermo, looking at the US position, what lessons do we have from that? How do you think things could really pan out across the UK and Europe?
Thanks, Patrick. So a couple of points on that. First, in the US context, for I think the last 5 or 6 years, companies here have had more guidance from OFAC than they had before in terms of how to deal with compliance with the trade embargoes and sanctions. And it's in that guidance, it's called the OFAC Framework for Sanctions Compliance. It's available on the OFAC website. I highly encourage everyone to look at that, because what it basically comes down to is something we're all very familiar with, which is a risk-based compliance approach. And what OFAC drives at is you need to scale your compliance to your business risks, to the risks you are aware of, or if you're not aware of them, make yourself aware of them before you undertake business that might put you at risk. When you do that, then when you have a problem, you begin a discussion with OFAC on a much better footing than if you did not. And the penalties here are, they've been increasing steadily every year, and they can be incredibly high. Many of the large banks, European banks that had US operations, have paid sums in the billions of dollars for extended, long-running violations of US sanctions. Some people would argue some of those sanctions, some of those violations weren't real violations, in the sense that the banks probably would have argued against jurisdiction by the US. But in most of those cases, when you actually dig into the facts, you find that the banks were actually doing quite a few things to try to disguise their activities. That implies, certainly from the OFAC perspective, that they knew they were doing something they shouldn't be doing and took actions to disguise their behavior, which I will tell you in the OFAC mindset, and again, I'm speaking as a private sector lawyer here, that is really going to get them very worked up when they see a company that is taking steps to actively go around the sanctions. But in terms of the penalties, there's a fairly complicated structure under US regulations, and there are 2 laws that primarily set those forth that can bring penalties up to 1/2 of the transaction value that's involved. But to give you an example of how that works in real life, when you have an investigation like that, when I'm representing a client, you're going to work very hard over a period of time to find ways to bring those numbers down by showing efforts to mitigate conduct. That starts, for example, if you discover that you are involved in a potential sanctions problem, going into the government first before they find out. A voluntary disclosure buys you a lot of goodwill, not just in OFAC, but in other regulatory and enforcement contexts that we know, FCPA being one of the most active in that area. So you go in early and you go in very open. That's incredibly important. Sometimes when we have that discussion with a company that is thinking about that, they might be looking, well, we can disclose this, but not this. Problem is, when you get into that discussion with the regulators, you really are basically agreeing to discuss almost anything of interest to them, because if you say, well, no, that's not really material to this, or doesn't really pertain to this, it can lead them down a far harsher path. So there is a premium here, really understanding all of your potential liabilities before you have that discussion with the regulators. Of course, you're in a race sometimes for a race of time here, a competition with the potential for the regulator to find out through their own means. And the most typical way that happens is banks have to file suspicious activity reports. Other entities involved in the transactions might be caught. For example, if you've been, one of the common ways in which we see these things happen is US company has been dealing with a UAE company. It turns out the UAE company is a front company for Iranian sanctions evaders. Someone else, some other US company figures that out, goes in to self-disclose. Well, the US government immediately is going to focus on that UAE entity and build a case around that. So if you're doing business with them, obviously the Unoil case in the FCPA context is very illuminating. Once you figure out who the central figure is, you can spoke out and create a much larger investigation. So that's another area. I think the other issue here is, I'm primarily speaking about civil penalties. In the rare occasion when you have intentional, so willful violations of US sanctions, and the Department of Justice, which is the only entity that can enforce the criminal side of it, working closely with OFAC, there you're in a very different environment, because there you have the potential for people to go to jail here in the United States, to go to prison, and the penalties get higher. But also, of course, you're dealing with a criminal matter in which the costs of defending the company can be staggering. And most companies are not going to go to court. They're going to settle, because since years and years ago, when Anderson, one of the large accounting firms, tried to defend itself in court, well, that didn't go very well, and no one uses Anderson anymore because they went out of business. So it's a very high stakes game of risk there. There have been some cases in the U.S. There were some Turkish bankers who defended themselves in a pretty notorious case involving Iran. I have no idea how much their legal fees were, but they can be sizable, as they can in a sanctions investigation. And in this case, in this respect, I would note there was a very interesting quote a couple of months ago, I think, from Lisa Monaco, one of the deputy attorney generals here in the United States, speaking to a conference. She said, sanctions is the new FCPA. And to some extent, I get what she was saying, that this is now going to be one of the major risks for companies operating internationally. But I will say, having done FCPA work almost as long as OFAC work, they're two very, very different types of problem sets for companies. FCPA, fundamentally, it's easy to understand. Bribery is a common language. It may be more common in some places than others, but everybody knows that bribery is inherently wrong. It's a subversion of the process. It's unethical. OFAC sanctions are not on the same caliber. OFAC sanctions are a national security issue. It's a decision. We're not going to do business with someone because we disagree with them. Now, the disagreement may be they are human rights violators, like many of the parties sanctioned under the Magnitsky Act here in the United States, because they have killed, tortured lawyers in Russia, for example. Or maybe they are facilitating terrorist attacks, which are clearly are not just something you can have a difference of opinion about. But there are many that are on the sanctions list because countries have difference of opinion on their foreign policy, as we do with many countries. For example, Iran, Cuba. It's not inherently evil to do business with Cuba, just the United States has a different view than most of the rest of the world. So when you're trying to comply with sanctions, it does mean you need to take a very different approach, because it's hard sometimes to explain why you can't do certain things in the business environment. It makes absolute sense for a German company to be investing in Cuba, but if that German company's US subsidiary does the same thing, they're going to have a lot of problems. And those are the complications that companies have been dealing with for decades now. It's not new in that sense, but the more complicated these sanctions regimes get, the more these edge cases become more difficult to deal with, especially mid-tier companies. I think Nigel mentioned before, the small Small companies are the ones that suffer a great deal of pain. I think in the middle tier, where they're more exposure to international transactions, it's especially difficult, and they can't necessarily afford the complex compliance programs that, while they may not work 100%, it's your first and best line of defense when you have a problem and you have to go into OFAC.
Thanks, Guillermo. That's fantastically useful. Now, Gillian, if I turn to you just in terms of the European side of things and the sort of financial impact that can be seen there in terms of either outright penalties or kind of reputational risks and the stakes for companies involved, what's your kind of view of that?
Well, just to come back to the basics, is that EU sanctions are not exterritorial, so they are only based for EU. And on the other hand, is that actually until very recently, until last July, the sanctions were locally, so based by each member states. So since last July, it has been decided by the European Commission. We have a new AML directive, the sixth one, and it includes actually a new authority, a new AML authority that will be able to supervise and enhance cooperation between the member states. So actually you have the impacts, but only locally. So for example, if you take the examples that involve OFAC sanctions, BNP, Société Générale have been sanctioned by the US regulators, but by the French regulator too. The penalties are very strong, and I can speak about the French regulator that actually they are very going forward. They are trying to really have a priority on AML CFT, because we saw that actually the terrorist attack that we had in 2015, for example, were something that we could have avoided if we had a proper program. And the penalties were quite high, even though the amount were very small. I would say that it's quite a challenge for Europe, the harmonization, because even though we have directive from the European Commission, each member state has its own way to implement. We saw the scandal, for example, recently of Lithuania, Danske Bank scandals recently, and we had many of them. So those is very challenging for Europe. Hopefully now with the new regulator coming, it will help to enhance and to collaborate. So it means that every time that a bank sees something that is a breach or any red flag, it would be able to actually send their report to the financial intelligence unit, the SAR, and that will help actually, because we'll be able from one country to another to have a visibility of any red flag in any sanctions. So I would say as of today, Europe is still far from US if we compare from the OFAC program, but it's still going there. We have many banks that have been sanctioned from the US program that helped actually to mitigate some risk and to implement a strong programs, because the penalties were very high. If you take, for example, the BNP case that cost 10 billion to BNP, without including the monitoring and all the resources that you have to hire for the mitigation of the risk, and have a proper compliance program. So that helped in, for example, filtering the transaction and screening, all this kind of, I would say, basic for a program that didn't help. If we take the side of, if we see the other side for FCPA in Europe, we do not have yet, I would say, a regulation that includes on the scope of the 27 members. But however, each country has its own very strong regulation, and we can take, for example, the case of UK that has a SFO that is taking care of it and has the UKBA. In France, 5 years ago, they have adopted a new law too. So that we are trying to, I would say, to take the path of US, that is like literally our model in compliance, because we had many in Europe cases, and without OFAC or FCPA, those violations would not have been seen in the investigation. I believe that's all on my side. Patrick, if you want to get the floor, it's yours.
Thanks. And I think you raise a number of interesting points have been raised by the two of you there in relation to the sort of spanning from the AML risk, both in terms of notifications, because banks tend to often be the driver of anti-money laundering suspicious activity reports because they handle the funds. So as a result, if the company's not making those reports, the bank is likely to be doing so. And if the bank does so, it's basically a race to the top or a race to the bottom. And if the bank is first there and the company isn't, then there's a risk obviously to the company in terms of penalties and the like. And certainly in the UK, albeit for individuals, it's sort of 7 years imprisonment if there is a criminal sanction. The reality is most of the sanctions in the UK have been financial services, regulatory sanctions, and have, like the BNP Paribas case, been quite significant in that regard. But Nigel, from your point of view, assuming that we can get your mute button and volume button and internet working again, what's your kind of view in relation to the banking sector and your experience there in terms of how it's reacting, how it's coping, and what changes can be brought in to make the system better?
I think the first thing is that there was mention made about the very large penalties paid by UK banks. Earlier, Guillermo mentioned it. The fact is they didn't need to do that. Before the USA Patriot Act came into force, I presented a breakfast briefing in London and explained to bankers exactly how Section 311 and 312 were going to work to apply those sanctions and how they were going to get caught by them. Large law firms, large accountancy firms said I was talking rubbish. Well, it's cost UK banks thousands of millions of dollars. I wasn't talking rubbish at all. And the reason I wasn't talking rubbish is because this was all known. There was nothing new about this. If you knew your subject, there was nothing new about it. I think that financial sector sanctions have followed very much the same path for the last 20 years. There really hasn't been anything new that they've done. Yes, we've had the stripping, but that wasn't the stripping, which was when information in a SWIFT message was corrupted to avoid reports. I mean, that was quite simply a fraud. I don't understand why there was so much fuss made about it as if there was something special. It was just a fraud. It was a document fraud. And had it been prosecuted as a document fraud, there would have been 20, 30, 40 bankers in jail. And that would have been the way to deal with it, not to say that let's find the bank, what was theirs, 500,000 or 500 million or something at that point, the Lloyd's one. So I think that banks have got away with a lot, or rather the people working in banks have got away with a lot. And until such time as we see enforcement against individuals, where it is clear that individuals have made the decisions, they have taken certain action, we knew exactly where the Standard Chartered case went wrong. We knew exactly which office the failures arose in. We knew exactly which officers approved the transactions. And yet they all walked away. This is not the way it's supposed to be. But it's also important to understand that outside the financial sector, sanctions have had a much broader effect across the whole of industry and commerce. The financial sector largely it's the same thing over and over again. It may be bigger, it may be smaller, it may involve different people, but the principles are the same. In relation to the non-financial sector, this is where we find much more risk that is not exactly hidden, it's just not really recognized, because we don't see necessarily where those risks can arise. So, I mean, the big case that made all the difference was the super gun, which was pipe work that was being sent from the UK to a sanctioned country in the Middle East. And it was alleged the pipes were of a military grade so that they could be used for a weapon which would allow shells to be fired over very, very long distances with a great accuracy. And it turned out that, in fact, there was something in place for that to give an effect. But we see also ordinary things being caught. For example, I may have mentioned earlier the guy who bought a video camera for use on his driveway, and that was a breach of sanctions because he was in Iran and it was held that was dual purpose. We've seen Land Rover getting Ford into trouble. And Guillermo said earlier that there have been, he refers to the case where there was a foreign company with a UK subsidiary, but actually, with a US subsidiary, and the US subsidiary got into trouble. There's actually a reverse of that case as well, ABB, where ABB Sweden was brought to account because it had a US subsidiary. And so the complexity of the system of the approaches is, I think, more than we tend to notice if we only look at the financial services sector. And I think that we also need to bear in mind that everybody is subject to sanctions. There's no saving for size. There's no saving for being involved in your own little business. There's nobody says you're only a 5-man workshop doing somewhere making widgets, therefore you're okay. Everybody is subject to sanctions. And as Dean said earlier, the cost of getting the data to be able to make sure that you're not dealing with someone you're not supposed to deal with is cost prohibitive for small businesses. And one thing that governments, the FATF, frankly, should do is to produce a free database of all the people that no one is supposed to deal with. And if the FATF were to take over something along the lines of WorldCheck and to create that as a global free database, they've got the resources. They should be doing that. And that would greatly help the small people, both in financial crime and in sanctions, that are exposed simply because they're doing the things that ordinary people do, and the law is designed for big things, for big companies, without paying attention to the smaller ones. I've stopped.
Thanks, Nigel. Dean, you and I have been sort of talking on the fringes via the chat about whether or not sanctions are now becoming more weaponized internationally and are likely to be ruled out a lot more frequently against the big guys and the small guys, as Nigel has been mentioning. What's your kind of takeaway in relation to that? What's your kind of concerns?
It's an observation plus a potential concern. I think it's been a really interesting few months watching the way the world has more swiftly aligned on the Russia-Ukraine conflict and come out with what I see to be a relatively well-organized set of sanctions. I mean, there were clearly things that lessons can be learnt from, but now with the news this week of the EU agreeing now an energy sanction regime against Russia as well, and the reduction in supply, I think the numbers bring it down to about 10 or 12% residual by the end of this year, which is largely for Hungary. The fact is they've just got their act together, and I think the collaboration and the way that they've done this, which I've never seen this well organized before when sanctions have been implemented. Maybe it's because the conflict is just so outrageous that most people just wanted to get on board quickly. But anyway, the fact is now that has been a systemized process. So it did lead me to wonder whether now that that engine's been oiled and it is proven to be relatively effective, although there is more to come, whether or not then they may choose to use that as a weapon, as you say, in smaller cases or less obvious cases, and whether the impact of that might be to then deter collaboration in the long run, and whether the pendulum swings the other way, because there'll be some countries that may not want to use the hammer of sanctions in particular cases. So I'm just interested in the panel's view on the likely prospect of this being used either more or with higher penalties, and how that systemization might play out in due course.
Yeah, well, certainly, I think from my point of view, it is the first time in a long time that there has been that internationalization of things. One, in the past would go to the UN and try and get some kind of resolution imposed there, but we've seen how that mechanism has not worked fantastically well in the past, and as a result, I think this is the new model of how to do it, and it has been, fantastically swift, and has acted, very quickly, and certainly in the UK in terms of the legislation that's come out. One does not now need legislation to name either individuals or entities to the sanctions list. It can be done a lot quicker. And I think as of the last count, there were over 300 individuals and entities that had been effectively sanctioned as a result of this one piece of legislation in March. So I do think it does weaponize things, certainly against Russia in this instance. And then obviously, I think in the future, it's a mechanism which could easily be rolled out again if you get international collaboration, or at least if you get EU and kind of UK collaboration or US collaboration, because clearly, as Nigel's just sort of pointing out, is that there's very limited UN support because it's quite a fractured entity. But I think it definitely can be rolled out a lot more. And I think if monies do start coming back in to government coffers, it's potentially quite an easy and quick way to to bring in sanctions and to bring in monies, because you have right at the start, banks have a duty to notify suspicions of crime. Then those suspicions get brought to the attention of the regulator in question, and then the regulator can go out and civilly recover monies from those who have paid, and monies automatically come back into the treasury. So it's a closed loop system against the bad guys, and ultimately governments want to get monies back from bad guys, and this is a way that's been shown to kind of work. And Guillermo, I see that you're nodding your head there, possibly back over to you to see how you see this rolling out, and whether the US experience shows that it will actually be rolled out a lot more frequently, and whether we can expect something coming up against China relatively soon, or whether we think that that's completely off script and never going to happen, and it's going to be the minnows that we go against.
No, Patrick, I think that we are going to look at the Russia-Ukraine sanctions and Crimea sanctions perhaps as a very large, but nevertheless a very distinct blip in the sanctions compliance landscape. And I say that because since largely, going back probably, I think as Ghizlane mentioned, the anti-apartheid sanctions in the 70s and 80s, there hasn't been that much consensus around imposing sanctions in such a clear and rapid deployment. Yes, there was obviously some consensus around Iran sanctions for a period of time until the JCPOA, but even so, in most sanctions regimes, there have been clear differences because, again, as I mentioned before, they're based on national security, on perceptions of international security that are different for every country. Every country has a different foreign policy for that reason, and national interests do differ. So I view the Russia context right now as an anomaly. I would be I, along with everyone else, was surprised that the international community actually did the things that we did this time. I was expecting a far more tepid and weak response to the invasion of the additional invasion of Ukraine that the Russians have undertaken, because the experience in the Crimea was far more limited. I would say, criticisms that I have from the international community, well, perhaps if we'd done more back then, we wouldn't be in this situation. But even more recently, I think if we had been clear that we were going to do this kind of damage to the Russian economy before the Russians sent more forces into Ukraine, perhaps they would have had second thoughts, because clearly their entire program in the Russians since 2014 in Crimea have been trying to isolate themselves from the impact of sanctions. They built up an enormous...
And certainly this is an issue which Dean has just been messaging me about, as to whether or not the threat could be brought out proactively to suggest,
right,
we're not going to go to the UN for a resolution because we'll never agree anything because China and Russia will always vote it down. But what we might do is do EU-wide or EU-US sanctions against you. Get your act in order. What do you say if you think that the Ukraine sanctions issue is a kind of black swan event that's not going to happen again? Do you think this one is more likely that it's used proactively as a threat in that sort of negotiation process to try and deter bad actors from becoming even badder actors?
I think it will. The question is, what are the likely scenarios for that kind of proactive use? I think China is a completely different set of issues. It's probably a separate discussion, but I think China is it's simply. I view the number of sanctions options there as far more limited. That said, the United States has imposed sanctions, has imposed export control sanctions on many Chinese companies. As you know, the United States has largely been in a policy for the last 5-10 years of trying to push Chinese companies out of the US economy in sensitive sectors. And the Chinese, in turn, have been doing the same for US companies. So our degree of mutual dependence has gone down, but it's still enormously high because of the manufacturing that goes on in China. So I think that a scenarios that I could view in the future where sanctions might be applied proactively probably are on smaller scale. In other words, smaller countries that don't have an impact on the global economy that China would certainly have. But I think what we need to take away from this is that one has to be very cautious about predicting the likelihood that countries will come together on sanctions, because in my mind, the strongest, probably the most powerful reason why everyone stepped up and did the things they had to do is a combination of Zelensky, who proved to be an incredible advocate for his country, and I think shamed a lot of leaders around the world into doing more. And then the harshness, the cruelty of the way the Russians operate in war, which is nothing new. Chechnya, Syria, you name the place, that's how they do things. But it really was so public and visceral that people really had to take a different view of it. I spent a lot.
Just picking you up on that one, though. One's got Syria, and one's got chemical weapons, and one's got effectively genocide in that jurisdiction. Do you think part of this reaction currently that we're seeing is because governments are just so embarrassed at how little they did first time round, and that they're worried that this is Syria Mark II, and that they are, because Zelensky has really shone the light on it a lot more than the Syrian debacle, he is a publicity machine, and as a result of chemical weapons were used, it would just totally embarrass the UK, Europe, the US, and the rest of the world who hadn't got involved. Do you think part of it is embarrassment and shame that's led to this overreaction?
I think that has definitely been an element for the motivation for countries to step up and do more. But look, even chemical biological weapons obviously are horrible things that we banned a long time ago, and then they got used. But what's happening in Ukraine right now, the attacks being done inside built up areas, are something that I think most people would have a hard time understanding if they saw it. I was in Sarajevo during the Bosnian War, and the destruction there was also extreme, artillery being rained down on a city that was completely defenseless. The level of violence is hard for someone who's lived in a normal country to appreciate. So I do think that the leaders of a number of countries have reacted more strongly this time because of that. Interesting question is, why is a good part of the rest of the world not following those footsteps? And I've had conversations with good friends of mine in India, for example, in Africa. There are a lot of countries out there that are either very quiet or almost on the other side of the issue. And it's kind of an interesting question about why they don't view this conflict with the same severity that we do in Europe and in the United States.
Well, certainly we can pick that up in a second. I'm just keen that we get some final thoughts from Nigel on this, not because we're about to end, but because Nigel needs to disappear off shortly for another meeting. And as we've got his online presence here, we should maximize it as much as possible. So, Nigel, any particular thoughts from you? I know that you had some particular concerns about the issue with China and such jurisdictions about a sort of further international flare-up as opposed to a sort of regional one, but any further thoughts from you?
I think that we need to separate when we talk about national security, and as Gwen said, it's putative national security in many cases, we need to separate commercial aspects from genuine political and genuine national security or international security efforts. The fuss for the USA over China is commercial. It wants to maintain its dominance. It wants the US dollar to remain the dominant global currency, and it can see the yuan is coming out of that, is coming to challenge that, and it doesn't like it. And so, this is just big boys being silly bullies to each other. Where the real threat arises is with China's expansion in the South China Sea, where it has taken islands which are outside its outside its legal borders, but extended its legal borders, or so it says. It has, for example, built a very large airport and is turning an island into a very popular resort. But the military concern, the intelligence community's concern, is that this is actually just hiding what is effectively a forward base to get China further and further into the South China Sea. Now, some of this is talking about oil and other minerals. So again, it comes down to commerce, but there is a genuine security question mark. How far is China going to continue to expand its maritime borders? What's it going to do when it reaches the Spratly Islands, which is in dispute between 3 different countries, one of which is Malaysia, where I live? Are we going to see that there is going to be standoffs between military vessels amongst members of ASEAN? Now, that would be inconceivable almost amongst members of the EU, but it's not inconceivable that we're going to see that kind of thing amongst members of ASEAN. And bearing in mind that the USA considers itself to be a Pacific nation, it says that it has an interest, if not a right, to take part in these discussions. So I think that whilst we are absolutely right to be concerned about the brutality of what's going on in Ukraine, I think we also have to bear in mind that if we look at the amount of sunflower seeds, we look at the amount of wheat that the world is not getting because of this invasion, we can see that economics goes a long way to looking at this, at what action is being taken all over the world. I think it would be a grave mistake if we assumed that sanctions were only about military action, because the military action is more often than not possibly frustration at a failure of one large country to get what it wants. And so it ends up going off and bullying other people. Then we end up with sanctions because we do have behavior which is unacceptable. I've got to go. Thank you very much for listening to me on the times when I wasn't cutting out. It's been very interesting, and hopefully next time.
Thank you very much indeed,
Bye-bye.
Nigel. It's a pleasure for you to join us. Ghizlane, if I can return to you in terms of any of your additional thoughts into whether you think Ukraine is a one-off, whether you think that the kind of UK motivation in order to get involved and push things forward was in order to try and improve their ratings during the Eurovision Song Contest and try and get European backing for their songs, or whether you think it's the advent of the future and this is the way forward for international collaboration and cooperation, and that we're going to see a lot more of this. What's your kind of take on that?
Well, first of all, I would like to come back to one point that mentioned Guillermo about the EU and the vision of Ukraine. I believe that the fact that Europeans are very close to Ukraine geographically, it really impacts the strong sanctions. I think that's why Syria was not that strong, even though the sanction, I would say that Russia and Syria are not involved actually in the global economy as the same. For example, you can see that Russia in 2018 was ranked 12th as the economy of the world, when actually Syria never had this kind of economy. and export and import, it was not that integrated. I believe that's why it worked too. And then the population in EU is very had a projection. They were like, guys, it's at the front of our door, it's in our borders, so it can happen. So if it can happen, you can see that actually the governments, they really helped, even in welcoming refugees, and all this fear actually, I think, impacted the decision of politicals. So that's why I think it's a different context. However, it's a good thing, and I believe that they should go further in the sanction measures. On the other hand, that you mentioned India, I believe that India today is not taking any side, because India has a border with China, and they can't actually decide to take the side of Russia, and they need the partnership that they are building with EU and US. I mean, since the Prime Minister Modi came on board, I mean, now maybe 6, if I'm not mistaken, 7 years ago, it really, really changed India in the fact of, I would say, globalization, economy, partnership. So it's very difficult for Modi to decide either he goes for Russia or for EU and US. That's why they're staying like very neutral, actually, because the border is very important. They have issues in the border since like 2 years. They had some small fights with China. So for them, it's important to be neutral. If I come back to your point, I think that actually I'm kind of aligned with Guillermo. It's very unlikely that we can predict if another case will happen, and that all the worldwide will have this kind of commitment, this kind of consistency. Here you have EU, US, Canada, all the Western, I would say, developed countries are very strongly firm and against what's happening in Ukraine. However, we can't predict what's going to happen, because I mean, what happened in apartheid, no one could have predicted too. So it's very difficult, but I would say that it's a big step, that actually all those countries are really aligned, and that we are ready to ban 90% of our import in oil by end of the year. In EU, it's a very big step. It means that we have a core value that still we are going for it. When there is any violation of human rights, we do have this core value, and it's very strong. So then any situation can happen, but I believe that every situation in economics measure are very unique, and the politic that is engaged is very unique too. As he said, Guillermo earlier, he mentioned Cuba. Indeed, in France, I mean, in Europe, we didn't have the same way of seeing Cuba. But this time it's quite historical, and we should like be proud of some kind of good collaboration and coordination, that we're taking step forward. But in the same way, we have still some progress to make, I believe so, because we do have many countries where everything is not as we would like to in terms of human rights. Guillermo mentioned Chechnya and Syria, but you do have Iran too, that's still like struggling since many decades now. So we wish the best.
And just, we've gotten a question from the audience, and if anybody does have any other questions, please feel free to list them in the chat box at the side. But it's a very practical question in terms of what does one do about sort of client monitoring and notification obligations. And obviously, notifications will really depend on what your kind of risk appetite is, but certainly in the UK now, if you make a financial payment, you are liable. So as such, it's plainly in your interest to notify. And certainly from a legal perspective, we're seeing a huge uptick in terms of companies approaching us and making such notifications or looking to make such notifications. But the prior question is, what about the client monitoring? You know, how can you, because these are changing on a daily basis. You know, the UK's already got nearly 350 sanctioned entities since the end of March of this year, in a very short period of time. And certainly what we are often advising is cross-checking across different databases such as Dow Jones, Thomson Reuters. You know, you will know others, so I'm not getting sponsored by them, don't worry. Dean, in terms of your approach, what's your takeaway in terms of client monitoring and notifications?
Yeah, I think just to prepare for the future as well, and obviously responding to the current, you just have to get way more systemized and automated at this process. I mean, in the old days, it was quite heavy duty, and I even remember manual access to some of these systems to check on names. But these days, it's all relatively straightforward electronically. And I agree, it's probably quite good to hedge and get a couple of different suppliers in the mix, because some will act and be more responsive than others in terms of their relevance and being up to date. But I think that's the only way forward. Organizations need to put more effort and money into systemizing and automating that sanctions checking. And back to a point that Nigel made earlier, of course, bigger companies pretty much have these platforms in place. It's just about fine tuning how they do it. Maybe a couple more resources, but again, automation can mitigate that. But for the mid-sized companies that maybe don't and haven't had to worry about this before, suddenly in the UK they do. So I think there's a huge opportunity for some of these sanctions entities, checking agencies now to provide a fully outsourced service for those sort of companies. And that's what I would encourage them to do. They're just not going to be skilled enough to do it themselves. And so having a relationship where they can just throw it over the fence to an expert organization to do that is probably quite useful at this time, and likely to stick for the future, because we don't know yet. And I do see Ghizlane and Guillermo's point about we don't know whether or not this will stick, and likely not. But there may be another European incident, or there may be another global incident where it is. And the fact that it's been so successful now, there will be a sort of expectation that companies can adapt more quickly next time as well. So I think it makes sense to build robust processes that you can just get out the bag again, no matter what happens in this particular incident, and keep them ready to go. So more outsourcing, more systemization, I think, is likely.
Patrick, if I may, I wanted to touch on two things that Dean mentioned that I think are very important. The first is, if you're a strategic kind of a company in terms of how you approach your business dealings, you don't just want to build a compliance program to prevent you from dealing with bad actors. You want to build in some mechanism by which you can anticipate these geopolitical risks. I'll give you an example. At the beginning of this year, I started having conversations with companies that I know have some supply chain interaction with Russia, and beginning a discussion around maybe you want to change your payment terms on, payment before delivery, payment before, because the risks of getting something trapped in the financial system were going higher and higher. The same thing if you're operating in countries that have a lot of human rights issues. Myanmar, Burma, for example, is a good one. You want to be extremely careful of who you get into business with, because they may not be sanctioned today, but they could be sanctioned tomorrow. And sometimes sanctions have a period of time during which you can become compliant. They have licensing and wind down windows, but often they don't. In Libya, for example, I had clients that had ships that had to be turned around right outside of the port to avoid getting into a sanctions mess. So I think that's a very important component there. And then the other thing that I think is key here is I do think that the example of Russia-Ukraine sanctions is going to deter smaller countries from doing things that might put them in the same position, because they've seen how powerful it is. I don't think it'll deter China necessarily, but many other countries may be rethinking in the future, I hope, doing foolish things like invading their neighbors or undertaking, massive human rights violations because of the power of these sanctions that have now been demonstrated when they are integrated into the international economy.
Thanks, Guillermo. So we've now got, I think, 2 minutes left before Ariana officially sort of drops the mic and pulls the plug. So do we have any further thoughts? I think we just heard from Dean, myself, and Guillermo. Any thoughts from any additional thoughts from you, Ghizlane, before we hand back to Ariana?
Well, I think that we may add the fact that the tool that you would choose needs to be really fine-tuned. It means that you need to work literally well in new scenarios, because knowing the customer is not enough. It's more on the transaction that you have a risk, because I would say that today, even the mid-sized companies, they have the best knowing customer due diligence tool and process. But the transaction is whatever gives you the breach. And because the transaction coming and out and inside your company, and that's where you have to be careful, and that the scenarios can really help. And then I believe that Guillermo is quite right in the fact that you can anticipate the risk, because that will help you in your risk mapping and your classification of risk. It will help you to see where do you have to put more attention. If you see that the wind is going this side, maybe it's time to check on your portfolio and which kind of third party do you have, and if they are in this side, how can we mitigate the risk? But compliance, it's always changing. It's a regulatory side that's always moving. So unfortunately or fortunately for some, I would say that you always have to be aware of what's happening. And it's not only by the regulator side, but geopolitically, it works it's quite linked actually, and you have to be aware of that.
Can I just very quickly add to that, Patrick? Sorry, I think both Ghizlane and Guillermo are absolutely correct. And the advice I give my clients is exactly what they're saying about anticipating risk and commercializing your supply in a way that mitigates or prevents. The challenge is, and this is where I think business leaders really need to just think long and hard, is how willing are they to compromise their revenues for that? And they're going to have to. And this is a decision that business leaders need to make. They need to refuse to participate in a commercial arrangement that puts them at risk, rather than count the dollar signs they may not get. And it's just one of the big challenges I'm seeing day to day with some of my clients.
Thank you, Dean, and thank you, everybody, for joining us in terms of both our speakers. I'm sure everyone would like to extend thanks for getting together such a great panel of experts, and obviously to Nigel, who has just had to disappear off. So that's really it from us. If anybody has any additional questions, please feel free to drop us an email. Feel free to link in with us on LinkedIn or whatever it is that you do with LinkedIn, and you will see that there's some additional resources in terms of the banner and sanctions, which has been sent out in advance by Ariana, which shows the extra and recommended readings, and that has details in relation to Dow Jones, Adverse Media Effectiva, LexisNexis, and Refinitiv, and other matters like that. So please take a look at those. Please feel free to drop us a line. You'll see our LinkedIn details. We're all available via internet. It's difficult not to find us these days. So that's everything from us. Thank you very much for joining us. We look forward for you to join us at future events, and I'll hand back to Ariana, and then she can introduce or just finish things off by letting us know what's next on the ICRM compliance series of seminars. Back to you, Ariana.
Hi, thank you, Patrick. Well, ICRM is looking forward to host everyone in June, which is on innovation, and I'm not flashing it because, as always, with the war and sanctions, topics have been changing every other 2 weeks. So do always check out LinkedIn, which I have seen everyone following us, and also please keep a lookout for our emails. And in case our emails end up in your spam boxes, so do take a look at your junk mail in case they get filtered out. We will be sending updates as well.
Fantastic. Thank you very much, Ariana, and thank you very much, everybody, for joining us. Have a great end to your days. Goodbye.
Thank you. Bye.
Cheers.